SJC-12695, John Doe, number 23656V, Sex Offender Registry Board.
Mr. Tennant, good morning.
Morning, Mr. Chief Justice. May it please the court, Eric Tennant on behalf of the appellant, John Doe. The hearing examiner in this case abused her discretion when she failed to credit a qualified expert's testimony, or opinion, I should say. And it was error because she believed that that expert's opinion, or methodology, if you will, had to mirror her task. But it was wrong based on the standards set in SORB's own regulations and just the standards of administrative law as we understand it. And so I want to begin with this argument.
Can I ask, this is the same expert who said he was safe to be released before? This is the guy who said this, is that right? I just want to make sure I understand that.
You may be referring to that the expert in this case had said that he had evaluated the same person decades ago.
And said he could be released, and then he raped someone after he was released, right?
I think that's, I mean, if you're referencing what he talked about in his testimony, I think
You
you're correct
tend to be
about
pretty precise. That's right?
that. I believe so, right. He had done an evaluation decades ago in between, when he was being released from his first incarceration. And at a point when,
So, gets it really wrong once before. Does that mean that expert has to credit that?
I take issue with the gets it really wrong for a couple of reasons.
Well, he
So-
got it wrong. He wasn't sexually dangerous, and he actually proved to be very sexually dangerous.
There's a couple issues with saying that he gets it wrong. Number one, all these experts make opinions about what they think is likely to happen. No one says one way or the other, this is definitely going to happen or that's definitely going to happen. And what you do is you make your best assessment at a time. He did that opinion decades ago, and that matters because it was at a time when the research was different. And when he testified in this case, he was using actuarials, he was using validated instruments that did not exist at the time. He was using a method that the regulations themselves acknowledge are valuable, that came into existence in the last decade or so, and you have the amicus brief from MATSA.
He's using part of the proposed protocol. He's not using the whole protocol, right?
You mean SORB's protocol?
Yeah.
So this is the crux of the issue because he doesn't need to. And so what you have is essentially elements that SORB, who has the burden of proof, has to show. And this is stated in the regulations, it's stated in the statute. SORB has to prove risk and dangerousness and public availability of information. They have to prove each element to whatever standard they're trying to get. So if they want to argue that someone's a high risk, then each of those elements have to meet the high risk standard. And so all assessments of risks are just that, assessments of risk, not assessments of dangerousness. Experts don't do that. So when you have an expert opine as to someone's risk to reoffend, we are only dealing with that first element, just by definition of what doctors do or what psychologists do, just by definitions of what a risk assessment is.
But Mr. Tennant, along those lines, I mean, tell me if I'm oversimplifying this, because I might be, but an expert at an adjudication doesn't have to be an expert on every element of a crime, cause of action, civil case, or
Yes.
defense. The expert can be called on a discrete issue.
I don't think you're oversimplifying. That is exactly my argument, which is when you have multiple things that have to be proven, the party on the other side of the burden of proof can only attack one thing if that's what they want, and that can be successful. And so when you have an expert, you might have an expert that can meet multiple elements. You might have one that meets one. You have this in tort law where it's an expert on negligence but not on damages, or an expert on damages and not on negligence. I was thinking about it in terms of the civil commitment context, which is similar, which again, the experts in those cases, when they talk about risk, that's what they're talking about. Even though the jury is told they can consider many things, including what level the harm is, but the experts don't come in to talk about that.
And you were going to get to Mr. Tennant and how this comports to administrative law. You told us this is a natural part of
Yes.
admin law, which, in my understanding, has to do with credited experts.
Yes.
And then the ability. Can you explain that to me, please?
Sure. So this is unlike, for example, when you have a jury trial and you tell a jury you can accept some, all, or something in the middle. The standards that have been set for administrative law is an agency can reject an expert if they give a specific valid reason to do so. And so you have the cases that talk about that if you have uncontroverted evidence in one way without anything to their side, that's not a valid reason to reject an expert. You might have a situation where, for example, the hearing examiner in this case has factual differences with the expert and says, you know, there's an uncharged crime that I credit that the expert doesn't. Because of that, I don't credit his opinion. That's a valid reason to reject an opinion. But what you cannot do, and what an agency cannot do, is reject an expert opinion for a legally insufficient reason. Meaning, in this case, she rejected his opinion because she said he did not consider dangerousness. But he's not supposed to, and he doesn't have to. And so she held this expert to a legal standard that was inappropriate. That's why it was inappropriate to reject it here.
Why is he not supposed to consider dangerousness?
I
Don't
should
the
say, he
qualified
doesn't
ex-
have to, I should say.
Yeah, that's a whole big difference, right?
But I say not supposed to in that, again, that's not what experts typically do. They don't do assessments of dangerousness.
Don't the qualified examiners do both?
What's the difference between risk and danger here?
Sure, so risk is how likely you are to do something. Danger is if you do that, what is the harm that's gonna come from your conduct? And so qualified examiners,
But experts don't evaluate how likely you are to do a particular crime?
they might have an opinion about what you're likely to do if you do it, but when an expert does a risk assessment, what they're saying is this is how likely you are to do it.
But
And
to,
then-
but to do something, right?
do something.
But don't they, I mean, don't experts say, based on this person's, at least in the SDP context, malady, this is what we're fearful of them doing? The difference between a rape and a exhibitionist, a rapist and an
Yes.
exhibitionist is huge, right?
It is, but then it is up to the fact finder in an SDP context, the jury or judge, in a SORB context, the hearing examiner, to make their value judgment about the severity of that harm that's anticipated, and what, you know, how that would present a danger to the public. That then becomes a value judgment that fact finder in whatever context has to balance however they're gonna balance. So they listen to the expert to say, okay, this person is very unlikely or very likely to do this, and I, as a fact finder, credit that, you know, one way or the other, and I believe that if they do it, they're gonna do this, and I believe that should be enough to warrant a certain level, or should be enough to warrant civil commitment, or whatever it is. But it's that value judgment that experts don't do.
Can you give me an example, Mr. Tennant? So when you have the expert given a piece of the opinion, and the expert does not credit that, what findings does the expert have to make?
What findings does the,
What findings would be appropriate in order to?
you mean for the hearing examiner?
Yeah, I messed up. So
Sure.
the hearing, what would the hearing examiner have to find in order not to credit this?
They would have to articulate the valid reasons that the administrative law says a fact finder, an agency, can reject an expert. So I gave you one example, which is we have different opinions about the facts of this case, and I believe this person committed this uncharged conduct and he believes he didn't. They might make your run-of-the-mill credibility determinations, which is to say, I sat here and listened to the testimony and the person was forgetful and confused this case with another case and I didn't find them credible, or they were impeached in some way. And so that's a valid reason to reject someone, just to say, I don't find them credible. And so you have those things that administrative law says you can use to reject. But what you cannot do is, again, impose inappropriate legal burdens on that expert that are not required.
So are you saying the expert didn't give a good reason, or didn't give a reason in this case, or didn't give a good reason?
The hearing examiner in this case did not give a good reason. She gave a reason.
She gave a reason.
And the reason she gave was because she said this expert did not look at this, did not use the same methodology that she used, and did not assess dangerousness in the way that SORB has to. That's the problem. He doesn't have to use the same methodology. SORB's own regulations acknowledge that experts are going to come in to assess risk and use possibly different methodologies, so you can take that into account. And there is nothing that requires him to give his assessment of the dangerousness part, that value judgment that the hearing examiner has to do. If there is no testimony about that, then she is free to draw whatever judgment she wants about that, the value judgment of the danger that might happen, the harm that might happen. But she also has to make an independent finding about risk. And that's what the expert was talking about and saying, I think his risk is low, and he gave his reasons, and he talked about the actuarials he used that.
So she could have said he's full of baloney?
If, it depends on how she said it. If she said, I didn't find him credible because, and then gave valid reasons to not find someone credible, because he contradicted himself, because he was impeached on this thing, because he couldn't
I just
remember
don't believe
someone.
him. I just don't believe him.
I think she wouldn't be able to say, I don't just believe him, without being able to support that somewhere in the record.
She doesn't have to accept the methodology, though, does she?
She can reject the methodology if there's a reason to reject the methodology. So if she says, for example, he misapplied the test, he didn't do the test correctly, or if she said the test is not an accepted test in the field, that would be a valid reason to reject that. You don't have that here because it was uncontradicted testimony.
Can I try this
Yes.
analogy? Let's say that it's a Commonwealth has to prove criminal responsibility
Yes.
beyond a reasonable doubt, and the defendant calls an expert on wrongfulness of the conduct, but not on conform the conduct to the requirements of the law. The judge can't say to the jury, all right, well, disregard what the expert said about wrongfulness of the conduct because they didn't give you an opinion on conforming conduct to the requirements of the law. You can call an expert just on one way where the Commonwealth might not prove McCool beyond a reasonable doubt without
Correct.
calling an expert on the other way.
And the court, yeah, correct. And on the same hand, they wouldn't say, you can take this opinion's expert for criminal responsibility. They wouldn't do that. They would give an instruction specific to that case saying, you heard expert testimony about this, you can credit it if you find these
Yeah,
things.
you can't say to the jury, well, don't consider the expert opinion because they only talked about one of the ways.
You can say you can consider it for what they talked about.
Right.
And that's what I'm saying here is I offered it for one prong, one element, if you will, and that's what it should be considered for, but she rejected it as if I was offering it for a different prong or for both prongs, if
But
you will.
I mean, as I read the hearing examiner's opinion, there are two things she did, okay? One thing is the point you're making, which is that he didn't consider the determination of dangerousness, and your point is, well, you need to find a high risk of reoffense, and if that's the only element that he ascertains and it's not a high risk of reoffense, he can't be a level 3. I understand that point. But she also said, listen, the statute requires me to consider a set of factors, and he didn't consider some number of those factors, and I'm required to, and I, complying with the statute, look at those factors, and I say that I come to a view because of those factors which he did not consider. Is that fair game?
That's fair that she said that. I think there's a problem with that. So she does have to consider all the statutes because all the statutes cover all the different things she has to find. Some of them cover
all the
risk.
factors in the statute, you mean?
The,
I mean, all the factors that are set forth in the statute.
yes, set forth in the statute and set forth in the regulations.
Right.
And those are factors that speak to risk, that speak to dangerousness, sometimes at the same time, sometimes separate. Some of them speak to public availability. So she has to consider all of those because she has to make all of those different findings, and then she will plug the factors that deal with risk into her analysis of risk and the ones that deal with danger into danger. But when my expert is testifying, or when an expert is testifying, he's considering the same factors that deal with risk, and he's saying, as to these factors that deal with risk, this is my assessment of them, and this is whether how much or how little you should weigh it. So again, that's the mistake, is she's saying, well, he should be doing what I'm doing. But he shouldn't, because so much of her analysis doesn't have to do with risk, or so many of those factors don't have to do with risk. And I made a list, it's just to figure out which ones deal with risk and danger, and you can go through it and see there's many of them deal with risk, but many of them deal with both, and some of them deal with just danger.
I've done that too, perhaps not as carefully as you have, but again, put aside dangerousness.
Sure.
I understand that point.
Sure.
But if would it be okay, and I've not looked as carefully as you have, would it be okay for a hearing examiner to say, listen, I've got to consider 8 factors as to risk?
Sure.
He only considered 5 of them. And I have looked at the other 3, and I find those to be important, and he didn't even consider those.
So if it was said in that way, I think that's okay, meaning now she's giving a valid reason to reject the testimony, which is he did not consider things that must be considered, right? He did not consider these 3 factors of risk that I find exist. I mean, at least they have to exist, because if they don't, that exist in this case and are weighty for these reasons. And because he didn't do that, I think that's valid.
Don't you think that's implied in her findings?
I don't think so, because she says we consider many of the same factors, but we come out differently. And then she says, and he doesn't consider the ones about dangerousness. I don't think you can imply it with this decision. If she meant it, then she needs to be given another chance to write it, but I don't think that's what you get from reading this. I think it's clear that's not why she rejected his opinion. I think it's clear she rejected it for the dangerousness factors. But again,
Consider,
excuse me.
which he did not consider.
Which he did not, which he concedes he did not consider, and says one of the first sentences out of his testimony is, well, dangerousness is subjective, it's not something I really do.
The basis you get for this, you have to credit, is a tax case, right? That's your only citation for this idea. Do you have any SORB cases or any cases? Because tax has a different standard of review. The burdens of proof are more convoluted. This idea that you have to credit, and by the way, even the stuff you cite says if you've given the best available evidence and it's uncontradicted, I don't know where this principle comes from that you have to partially credit an expert. Where does that come from?
It does come from administrative law. I do believe there's a case also that has to do something in the liquor licensing area, but I'm sorry, I can't cite it off the top of my head. But that is classic administrative law in the sense that we treat it, we look at it a little differently than we look at courtroom procedures. And because so much is in the record, and because we impose on fact finders, whether in SORB or other contexts, a duty to explain and a duty to put on in writing.
Is there anything in the SORB regulations that says that this burden is that we credit? I mean, because you don't even need expert testimony in SORB, right?
You don't need it, but then you might not be able to rebut some of the findings about risk. There's nothing in there because I'm saying it's an administrative law principle, not a SORB principle. The SORB regulations, as all agency regulations, incorporate 30A and incorporate, the General Administrative Procedure Act. That's not, as long as it's not changed in the regulations. So I think that part is fairly standard when it comes to agency decisions.
Okay, thank you.
Thank you.
Mr. Bossi.
Good morning. May it please the court. John Bosse for the Sex Offender Registry Board. In this case, the hearing examiner properly rejected the opinion of Dr. Bard that the appellant poses a low risk to sexually reoffend. In doing so, the examiner properly considered the facts in this case, and it's important that in every sex offender case, we look to the individual facts. And what the facts tell us in this case is that one reason why the hearing examiner rejected the opinion of Dr. Bard was because he didn't consider all the regulatory factors that the hearing examiner is required to consider in her ultimate classification decision.
I understand that, but we have this distinction which we're working through with Mr. Tennant. I want to see whether you agree. Do you agree that it is not appropriate for the expert to say he didn't touch upon the issue of dangerousness, which is the regs require 3 findings: risk of reoffense, dangerousness, and then whether it will serve public interest. He only touched upon issue 1, and therefore I reject it for that reason because he did not address the issue of dangerousness. Is that something that is appropriate?
It's not appropriate for the hearing examiner to reject the opinion just because the expert didn't consider dangerousness.
Okay.
And in this case, she noted that he didn't consider dangerousness, and she noted that the Dr. Bard didn't consider all the regulatory factors that she's required to consider.
With regard to risk of reoffense? Okay, so you actually are in agreement, it may not be agreement with the facts of the case, but you agree that it's not okay to say, this Dr. Bard did not consider dangerousness, for that reason alone I reject it. You say you can't do that.
Right.
But you're saying you can do, Dr. Bard did not consider these 3 factors which I must consider pursuant to the statute and regs, and I think they're important, and therefore I reject it. That she can do.
Right.
And it's your view that that's what she did, and if so, where in her opinion are you pointing us to?
So at page 30 of her opinion, which is at Record Appendix 85, in rejecting Dr. Bard's opinion, she noted that he didn't consider all the regulatory factors that she's required to consider. For example, he didn't consider Factor 5, which is when an individual has been deemed to be sexually dangerous person. Factor 19, which speaks to the level of physical contact. Factor 22, number of victims. And I think most importantly, Factor 24, which speaks to an individual who was offered the opportunity to participate in sex offender treatment, but refused that treatment. And I say that that's very important in this case because the research has shown that participation in sex offender treatment reduces one's risk to sexually reoffend. In this case, the appellant had the opportunity to participate in sex offender treatment through the Department of Correction and refused the treatment because he didn't want any information being used against him in a Section 9 trial under Chapter 123A.
So
Now, in Commonwealth versus Hunt, we said he's right. You can't use that against him in an SDP trial because he's faced with the dilemma of having to go to sex offender treatment and admit everything and waive confidentiality, and then everything, then they would say, well, he's dangerous because of all the things he confessed to. So because he's in that dilemma, we don't allow you to use the fact that he did not receive treatment at an SDP hearing. Why should it be different at a SORB hearing?
Well, because based upon what the scientific studies demonstrate is that treatment reduces one's risk to reoffend, and we have an individual who was in state prison, his most recent state prison sentence from 1997, and didn't participate in treatment. It would have been beneficial for him to participate in treatment because it would have served as a mitigating weight in his classification hearing.
Okay, but we considered that in Hunt and said an SDP hearing, you can't do it. You can't, it's not admissible. So
Well-
why would it be not admissible at an SDP hearing, but admissible in a classification hearing?
Because in an SCP hearing, as this court has acknowledged, an individual's liberty is at stake, as opposed to a SORB hearing, we don't have that same liberties interests at stake.
factors 5, 19, 22, and 24, do they all go to the issue of risk?
I believe so, Your Honor. I know Factor 19 speaks to dangerousness, and I believe those other factors go to both risk to reoffend and dangerousness.
Okay, so 5, 22, and 24, which go to risk, the expert didn't take into account.
Correct.
Isn't this odd that they've separated risk from danger? Is this an unusual, the fact that the expert does this, it's the first time I've seen anything like that. Is that unusual? That they only will consider one aspect of the petitioner? And I'm surprised at your concession that they can't reject it because they haven't done the full analysis, because there's something odd about that, right? You're like doing the half you like. You know, you're not confronting the fact that this person raped people, which is makes him more dangerous, because we're interweaving these two factors, aren't we? So why is it not relevant that the expert chooses not to do the second part of this?
And I do apologize, Your Honor, I misspoke earlier. Because the statute requires a finding as to risk to reoffend and dangerousness, I think it's important that the expert consider both of them.
Right, but you, in response to the chief's question, you
Right.
said you couldn't reject the expert if they only did the risk of reoffense and didn't consider danger. I'm surprised by that.
Right,
because-
and I apologize, I misspoke. under the statute, you have to consider both. So if the expert doesn't testify or doesn't consider dangerousness, the hearing examiner could consider that in rejecting the opinion. So I apologize.
But you don't apologize, because you're right the first time.
No,
You've gotta
you're right the
find-
second time.
You've got to find a high risk.
Right,
So-
right,
So if there's not a high risk, it's on a level 3.
correct.
No matter what, no matter how dangerous the person's going to be as to the second determination, you have to find a high risk.
Right, and
Okay, so
But this is a level 2, right? He's a moderate risk,
it
not
has
a,
to, so it has to be a moderate risk.
right.
So the person has to find a moderate risk.
And just as an example, I recently had a case where the hearing examiner made the offender a level 1, and she said he posed, he has this general ongoing criminality, so his risk to, his dangerousness would be considered closer to moderate, but he hasn't done anything in a sexual nature since 1993, so the hearing examiner ended up making him a level 1.
Okay, I understand that, but the statute requires for it to be a level 2, it must be a moderate risk.
Right.
And so if the person were to find it's not a moderate risk, it can't be a level 2, correct?
If the expert were to testify to that?
No, if the hearing examiner were to find that it's not a moderate risk,
Right.
it's not a level 2, no matter what she may find as to the issue of dangerousness.
That's correct, and that was the example that I just gave.
Okay, so if it turns out that the expert only addresses the necessary finding of it being a moderate degree and says it's a low risk, and she says you're right, no matter how dangerous the person may be as to the crime the person would commit upon reoffense, it's still going to be a level 1, because it has to be moderate risk of reoffense under level 2.
In that example, if the hearing examiner found, agreed with the expert, that the individual is a level 1, yes.
The examiner, the expert can say, listen, you've got to, in order to find moderate risk, you've got to find moderate risk of reoffense and at least moderate dangerousness, correct?
Correct.
And if the expert says, I'm not going to discuss the issue of moderate dangerousness, I'll even concede that. But it's not a moderate risk. That's okay for an expert to do. The expert doesn't need to address the second issue if the petitioner says, I'm going to win on the first. You're not going to show that I have a moderate risk of reoffense. It's a low risk of reoffense.
Yes, so I would agree with that, but the examiner would have to agree with the expert's opinion.
I understand that.
Right, right.
and is it relevant that the expert for the petitioner is not addressing something that you would otherwise expect him to or her to address? Is that something that's appropriate to consider?
Yes.
Okay, because I think that's where the chief and I have different takes on what you're saying.
And I just think it's important to look at the individual facts of each case. So what we have is the expert didn't consider all the regulatory factors that the hearing examiner is required to consider. We also have an expert who relied upon 2 risk assessment tools, the Static 99R and the MATS-1. And we got to remember, with respect to a lot of risk assessment tools that the examiners, that the experts are using, are based upon static factors. And they're not individualized to the offender. They're based upon group estimates. For example, Dr. Bard in this case used the Static 99R, which is common for experts and clinicians to use. However, the authors of the Static 99R state that any prudent evaluator would also consider dynamic factors, and they also warn that it only has a moderate rate of accuracy. So, and they say that because it's based upon a number of static factors.
As it relates to those factors, I apologize for the redundancy. The only ones I'm concerned about that the risk expert didn't consider are the ones, the factors that you have to consider for risk. If there's 5, 22, and 23, whatever the factors you mentioned.
Right.
If the examiner has to consider those 3 factors in determining risk, and the expert didn't consider them, then that's a legitimate reason to not credit the expert.
That's correct.
But it has to be that those are factors that have to be considered for risk.
Right, that's correct. And I believe out of the, so there was factor 5, 19, 22, 24. Out of those 4, I believe the only one that doesn't address risk to reoffend is factor 19, which addresses dangerousness.
How do we know which factors apply to which of those 2 prongs? Is that in the regs themselves?
It is. So a number of factors do address both prongs, risk to reoffend and degree of dangerousness. There are some that only address risk to reoffend or dangerousness. And I counted.
And that's in the CMRs. We'll be able to do that matching from the CMRs.
Yes, Your Honor.
Okay.
I counted that there was 11 regulations that address dangerousness.
Why doesn't it enhance the experts' credibility that they're only willing to come to an opinion on risk and not both? I'm not saying that they're no help on dangerousness, but they're not stretching to give an opinion on dangerousness. They only feel like they can formulate an opinion on risk. I don't know why that wouldn't. I don't know why that detracts from the expert's credibility.
Well, I think it's important for the expert to address dangerousness because a number of the regulations address dangerousness and are supported with scientific research.
But maybe the expert in good faith can't do that because they agree with SORB. But it's enough to have success if the burden's not met for level 2 and it's good enough that they weren't able to show risk.
Well, maybe
That doesn't enhance the credibility.
and getting back to what Chief Justice Gantz stated, that if the expert can only testifies to risk to reoffend and the examiner agrees with that expert opinion, then if the expert's testimony was the individual poses a low risk to reoffend, and even though the examiner may believe that he's a moderate or high dangerousness, then I believe the examiner's only choice is to classify him as a level 1.
That's my point. You just said it better.
Sorry.
Okay, no further questions? Thank you.
Your Honor, thank you very much.